Want to welcome you all to our third and final session of this year's First Amendment Conference. It's an annual convening we hold every year, and this year the theme of the conference has been, as you can see, a revolution in religious freedom from the Declaration to the First Amendment. And we started this morning with the American Revolution and the way that religious liberty operates there and some of its historical sources and the struggle for various groups of Americans to find their place in the American political tradition and craft a tradition of religious liberty. We find ourselves now in the current term of the Supreme Court. So this afternoon's panel will give us a discussion by legal experts and educators and education policymakers from our community to consider the merits of a pending Supreme Court case that has sweeping implications for church-state relations and religious liberty throughout the country. The case is, of course, Oklahoma State Charter School Board versus Drummond. Moderating the panel today is Joseph Kerry, an elected member of the Utah State Board of Education and professor and chair in communications at Ensign College. Joining him is Erin Smith, who is associate counsel for the First Liberty Institute. We also have Michael Erickson, a partner in the firm of Ray, Quinney, and Nebeker, and also a wonderful teacher of students at UVU in our American Heritage courses. And finally, William C. Duncan, who is Constitutional Law and Religious Freedom Fellow at the Sutherland Institute. So please join me in welcoming this wonderful panel of scholars.
I'm just going to say these remarks from up here, if that's okay. I just want to, one, thank the Center for Constitutional Studies and Utah Valley University. I kind of stumbled onto this case, and when I read it, I was like, wow, this is history, right? Sometimes we read about history. We're living history, or at least the potential for history, and the magnitude that the ripple effect that this case has the potential to create. And so I reached out to Jim Moss, who teaches here at the center, and I said, Jim, I think this would be perfect for the Center for Constitutional Studies. This was like 6 weeks ago. And he says, yeah, this seems like a great fit. Let me talk to Matt and see if we can make it work. And I thought this was going to be in May or June. And Jim called me back and he said, Joe, the oral arguments for this case are scheduled for April 30th. And we feel like we should do this before those arguments. And I didn't know an academic institution could move that fast because we went from idea to today in literally the blink of an eye. So I want to say thank you to Matt, the center, and to UVU for recognizing the possible impact that this case could have. And I say that from my position as a member of the State Board of Education, right? I can see that this case could really upend a lot of what we have assumed public education looks like. And I also want to thank each of the panelists because we then had to reach out and find not just someone who could speak about this case, but we wanted individuals who really understood the potential impact, the law, as well as some of the upside and downside to this decision. And I want you to know that the First Amendment is something more than just an academic, esoteric exercise for me. I'm honored that my mom is here today. She, when she was 9 years old, just like the movies, her parents came into the room and said, we've got to leave. My mom was born and raised in North Korea. And when it became unsafe for her and her family to stay there, she fled to the South. And so when we talk about issues of free speech, when we talk about issues of freedom of religion and assembly and the right to petition, all those beautiful things in the First Amendment, they are more than just words on a page or things that we probably sometimes take for granted. And so again, I'm grateful for this institution and its leadership to make sure that those things are instilled, not just in the next generation of students, but through your programs, the teachers and educators that we have throughout the state of Utah. So thank you for that. What I would like to do is I'm just going to give you a brief overview of the first series of questions. Then I'm going to ask specific questions. I'm going to turn the time over to you to ask the questions that you may have on your mind. And then the big reveal is, last night I asked AI, how is the Supreme Court going to rule on this? And then I poured all this data into AI, and it spit out a very long answer, and I provided that to each of the panelists. And before we leave today, they're going to let us know whether they agree or disagree with artificial intelligence and what it had to say about what the Supreme Court is going to do when they decide this case. First, we're going to hear from Michael, and he's going to start with a very big perspective of these currents, many of which you've heard today, between religion, secular. Then we're going to go to Bill from the Sutherland Institute. He's going to address some of the flow of the current case. And then we're really blessed to have Erin here from First Liberty, because she used to work at the Department of Education in Oklahoma. Then she worked at the Attorney General's office. She used to work for the Attorney General's office in Oklahoma, and then the Department of Education in Oklahoma. They're one of the litigants. So that's really the insight that she'll be able to provide. So I wanted to let you know that's how we're going to start. Mike, I'm going to turn the time over to you.
Thank you, Joe. Joe mentioned that this case pending before the Supreme Court may make history, and I think that's absolutely correct. I think it's also correct in order to understand this case from the Supreme Court. It also helps to understand our history and where we have been. And it's been remarkable to me today, during the course of this conference, how much we have seen of that history that is so relevant to the issues that are going to be pending before the Supreme Court. I think it would be helpful to break down the three periods of history, some of which we have heard today described. The first period of history would be around the period of our founding and of the origin of the Establishment Clause. We heard described in the early morning session of the movement of disestablishment. We heard descriptions of Quakers in Pennsylvania, of other areas, other of the early colonies that became states of tolerance for religious freedom. There were also other states that had their own established religious traditions. And at the founding of the United States, there was a contest. There was conflict over and resolution over how to handle the issue of state involvement with churches. Anglican Virginia looked very different than the pluralistic society in Pennsylvania and Rhode Island. The same with Congregationalist Massachusetts. And over time, the First Amendment, and as well as in state efforts, the United States had resolved that issue by disestablishing, moving and separating the role of the state in having direct control, direct support of state churches, that disestablishment era. It's from where we draw the language of the First Amendment, the Establishment Clause, along with the Free Exercise Clause, these two twin principles of our religious freedom tradition. On the one hand, not elevating and enshrining a church, favoring one religion. On the other hand, not prohibiting or disfavoring other religions. And so that era is one that is going to be that's going to be part of the history for deciding this case. We heard some of that described this morning. Another period of our history that is significant is the 19th century, and some of the changes that were happening with immigration and the makeup of the country and some of the conflict that led to in school systems. In the beginning of our nation's history, of course, we've described this disestablishment, but that did not mean disestablishment of religion from schools. And for the early history of the United States, there was a tremendous, something that would be entirely unfamiliar to us in our day, tremendous cooperation, influence, integration, state funding of religious schools, and throughout many of our states, and they were predominantly of a Protestant tradition. There were variations, obviously, in those different Protestant denominations, but it was primarily Protestant. Then with the influx in the 19th century of Italian and Irish immigration, there became a rising tide of some nativist discrimination against Catholics. For a country that had a strong national origin identity of a Protestant identity, Catholic communities and Catholic influence could be viewed as a challenge. We heard that described this morning with respect to concerns over papal infallibility, etc., and some of the conflicts between Protestants and Catholics. And so in the 19th century, we saw in the mid-19th century movements to try to prevent any kind of support for Catholic schools. Rather than being so blunt in saying that there's going to be the exclusion of Catholic schools, these schools were described as sectarian. But it was not Protestant sects that were of concern at the time to those making legislation. It was targeted fairly specifically to Catholic schools that existed outside of some of the public school systems that were predominantly Catholic. And so there were a number of amendments. There was an attempt to amend the federal Constitution, referred to as the Blaine Amendment. It was ultimately unsuccessful in an attempt to ensure that there would be no sectarian aid to schools. But what was successful were statewide movements that many of our constitutions, state constitutions across the country, still have remnants of, or even direct and exact language from this period of time that prohibits any kind of aid to any sectarian school. It's the same here in Utah. Ours is, of course, not tied to a Catholic tradition, but to Latter-day Saint schools in the early history of Utah, and of concern and fears about Latter-day Saint influence in education, and so a requirement in our Constitution of no aid to religious schools, and our school system would not be sectarian. And so those are two of these elements that are going to be colliding now in this Supreme Court case. The third time period I'd like to mention to frame some of our discussion of what is happening is the modern era, and I'm going to describe this as mid-20th century until now. What we saw after World War II was a steady stream of Supreme Court cases, not in every case, but certainly as a general movement that viewed any type of religious activity within the school system to be an establishment of religion, not a particular religion. These were not. These were often neutral. They were non-denominational. Most of these cases are fought in prayer in public schools. But for anybody, which would be most of us here growing up from that time period, there's a sentiment, there's a feeling that you don't have any religion in public schools. So pervasive, so strong is this trend. I'll just give two examples. One is anecdotal. Another would be how extreme that this push would have been. Was that there was a time even when there was a question whether or not the recitation of the Pledge of Allegiance and saying the words "under God" might be considered an establishment of religion. That was a potential. A potential threat at one point, that courts might be ruling that there would be a Supreme Court decision that would suggest that even the words "under God," as students might be an establishment of religion. Anecdotally, I'll just share that as a teacher of American heritage here at Utah Valley University, I tell my students on the first day, I cannot teach the history of the United States of America without teaching about religious influence on the United States of America. I cannot do that and be true to the history of the United States. And so over the dinner table one night when I was describing some subject of class and it had religious influence in describing the events of our great history, my daughter says, "Dad," she's a teenage, she's 14 years old, "Dad, can you teach that at a state school? Can you teach that at Utah Valley University?" I said, "Yes, I can. It's our history, and I can teach it." But that's the kind of sentiment that for many years, decades now, people of faith have had a feeling that in the public schools, in our public life, that any kind of mention, and it's not the law, the Supreme Court doesn't prohibit that, but the way in which the Supreme Court cases marched during that time period, and the way in which just generally that's interpreted is that we have lived in an era where there's been a belief that you can't touch religion, that inseparable wall between church and state is an impenetrable wall. And now we are in an era where there is a new perspective because of the makeup of the members of the Supreme Court that we're now entering into a fourth period, at least in how I've sketched it out, but many different other periods as well. But this is certainly a new period of how our constitutional system is going to be ordered with respect to how it views church and state issues. We will have to see how this case is determined by the Supreme Court, but there's no question we are in a new and a different era.
Thank you.
Bill. Thank you, by the way, for it's a treat to be on the panel with each of you who are so accomplished, and I represent the underachiever category, but I love to be here. I also, just if you don't mind, I'm just so grateful to the presentations have been superb so far. I feel like when my kids were little, I remember reading something that said, even if your children can't pick up a book and understand everything it says, it doesn't mean they're not getting something. So read a couple of years or grade levels ahead, and I feel like I'm the person listening and thinking, wow, I don't know exactly what this is, but it sounds really fascinating. And I'm always grateful. The center is amazing, and really the work it does is remarkable. Well, I wanted to maybe just give you kind of a description of the case that we're talking about. Some of you probably know a lot about it, but maybe others don't. And I'm Erin and Mike, feel free to, if I'm missing a point that you think is significant to mention. So,
just by show of hands, how many of you would consider yourself familiar with the St. Isidore versus Drummond case that's pending before the Supreme Court? Okay, there's your audience.
Okay, thank you.
Thank you.
That's helpful. Well, so obviously, this is so painful for lawyers to try and simplify things. But it's like many states, Oklahoma has a charter school program where they can designate schools that are created by private entities, sometimes parent groups or a university can have a charter school, and those charter schools are then designated by the state. Everything I say is subject to somebody challenging it, but just go with me for a while. It's designated by the state as public schools, and so then admission to those schools would be free, like attending any other public school would be, as opposed to a private school where there might be tuition requirements, or there would be tuition requirements. And that's been a very successful, I think, most people in the education world would say that's been a successful experiment. It's been very positive and given parents some more options that they would otherwise not have because maybe they don't financially have the capacity to go to a private school. So Oklahoma has a charter school board that approves applications for schools that have been created by these outside entities, and then they're asking for designation as a charter school to be a public school in the state. And there's a lot of interesting regulations about this. One of the things that's it strikes me as being somewhat important is that the normal laws that would apply in a public school setting, like requirements about curriculum, and do not apply in charter schools. So even though they're treated as public schools, if there are some things that parents are uncomfortable with their kids hearing in a public school setting, a charter school could provide that option for them to do that. So recently, it's an archdiocese school that was created by an archdiocese of a Catholic archdiocese in Oklahoma, offered to become a charter school or ask for designation as a charter school. And in the normal application process, this charter would have to agree that it would not teach any kind of religious topics or what you would kind of expect in a public school setting based on what Mike described. But in that process of I guess negotiating, the state said, well, we won't hold you to that requirement. The school said, we will teach doctrinal topics. We'll bring the teachings of the Catholic Church into our curriculum. And the charter school board said, that's fine. You can go ahead and do that. And so that law was designation was made. And the state attorney general felt concerned. He felt like, well, this goes against the principles, again, that Mike described well, about separation, that this is sort of enmeshing is the word that they use in the case, the public school system with a sectarian school, as they would have described it. And so of course, a lawsuit developed. And so the Drummond that's in the title is the attorney general. Who brought a lawsuit to challenge the designation of the Oklahoma. Well, there's sort of two cases going on, but they were at this point they're being treated as one by the Supreme Court, and so the question the court is well, let me take a step back. So the Oklahoma Supreme Court ruled against the school and said, kind of again summarizing probably maybe making this too simple, but first, that by designating a religious school as a public school, the state has made them a state actor, and that means that therefore everything they do sort of reflects state endorsement, and of course then that raises the concern, wow, so does that mean the state is, by treating them as a state actor, endorsing religion, specifically the Catholic Church, because of that will be the teachings of the school. And then, but let's I may just leave it at that. There was more than one ruling, but I think that's probably the one that's significant here. And they also talked about this. They borrowed an idea from one of our U.S. courts of appeals, or the Fourth Circuit, called enmeshment. That there would be too much enmeshment between the. Maybe my tone is giving you a sense that it's not very convincing to me, but that the state and religion would get too enmeshed together. Good luck finding that in the Constitution, but that's that word is the word they chose, and so that's the Oklahoma Supreme Court felt that those things that was the case over a dissent, and that's what precipitated the school and the charter school board to go to the U.S. Supreme Court and ask for a petition for them to review that decision. And the court the courts decided that they accepted that case, they granted cert, and decided they would address two questions. The first is there a constitutional problem with the charter school board designating any other organization as a public charter school, but not allowing for a religion one. So the way to think of this is, are they discriminating against religious organizations that might be charter schools or not? So that's one question. And then the other question, somewhat related to that, I'm kind of. The other thing that's raised by that is there something in the way that the state of Oklahoma wants to approach questions of establishment that could even if they are, say, discriminating or treating religious schools differently, can they do that? I mean, does the state of Oklahoma have a right to ask for more of the schools than just the normal establishment principles, which if we want later, we can maybe talk a little bit about. Now, as you think about those significance, and Joe asked me at lunch, why would the Supreme Court take a case like this? Well, there's different ways of thinking about why the court might have wanted to address the case. One is a very recent history. Over the last couple of years, there have been a number of important U.S. Supreme Court cases arising out of the kind of this general school choice movement that involve religious schools. And they begin with a case called Trinity Lutheran, and then Espinoza and Macon. In those three cases, again, dramatically simplifying, the U.S. Supreme Court has said if a program offered by the state is available to everyone, religious organizations or people of faith can't be excluded from the benefits of that organization solely because they're religious. And in Trinity Lutheran, the facts aren't that helpful for this case, but in Espinoza and Macon, what happened is the state would give scholarships to students to use in private schools in the Macon case, because there weren't other public schools like literally in the vicinity, so they had to go somewhere. And then in Espinoza, it was just a more general scholarship program. And in both cases, the U.S. Supreme Court said, no, the states cannot exclude religious schools from this. But okay, so one way of seeing this case is the natural extension. Okay, well, this is the next situation. Well, if you can't tell parents they can't use their scholarship money at a religious school, then maybe you can't tell a religious school they can't be a charter school. That's one way of thinking about it. Another way of thinking about this, though, is there are some other cases and approaches that perhaps cut a different way. There's a case called Locke versus Davey from the I think early 2000s. Did you look at that? We talked about this last night, and I forgot. I think it's 2005. But and in Locke versus Davey, there was a Washington scholarship program that was given to students, and they could use to pay for college. And a student wanted to use this to go to a ministerial college. So his expectation was he would be an ordained minister at the end. The state of Washington said, no, you can't use it there. And in a divided opinion, the Supreme Court said, hey, usually, state scholarship money going to private schools is not necessarily a problem. But in this case, the state's concerned about it. They're concerned about being too close to religion. And so we're going to allow them to do that. So you could see this as a case to try and address that question and perhaps see an application of that principle that there could be, that a state at least, or let me put it this way, the federal courts may need to defer to the state's decisions about how close they want to be to interacting with religion in a kind of a formal way, if that makes sense. I think that's another way of thinking about this case.
Bill, let's do this because I don't want, no, it's not going too long, but I'd like to get Erin's perspective because she was at the AG's office in Oklahoma, Department of Education, and then let's get into some of the specific questions about the legal issues involved in this case.
Sure. So I guess, I think Bill did a great job of covering a lot of the legal background. So he talked about those three cases, Trinity Lutheran, Espinoza, and Carson versus Macon. In this case, we've, started referring to those cases as the free exercise trilogy, just to kind of shorten it up so we don't have to list all three every single time. And it's interesting that you said that Trinity Lutheran isn't that helpful because that's kind of what the Oklahoma Supreme Court said during oral argument, right? The Trinity Lutheran case is about this benefit to help make playgrounds safer. They were going to grind up used and old tires that couldn't be used anymore to form the play surface. And then they told Trinity Lutheran, you can't have any of these tires. And so the United States Supreme Court said, well, that's a generally available public benefit. You can't exclude religious institutions from that just because they're religious. And the Oklahoma Supreme Court, one of the justices during oral argument said, well, this case isn't about tires, so that doesn't matter. But the principle still stands, right? And so in light of those three cases, the Archdiocese of Oklahoma City and the Diocese of Tulsa decided to apply to have a charter school with the Oklahoma Charter School Board. This charter school is a virtual charter school, and so it's different than a brick and mortar. It would provide, virtual education to students across the state of Oklahoma. Oklahoma is largely a rural state, and so it's very sporadically populated. And the archdiocese and diocese saw a need for, we want to be able to provide a quality Catholic education for free to students that don't have access to that type of education in their communities. And so they, ask the charter school board, then turns around and asks the current attorney general at the time, whose name is John O'Connor, can we do this? Because we see that the Charter School Act says we can't have sectarian charter schools. We see the Oklahoma Constitution has a no-aid provision that many refer to as a Blaine Amendment, because that's what it is. And the Attorney General said, well, in light of these 3 cases that the Supreme Court has said, yeah, that's not valid that this law would preclude St. Isidore from being a charter school. So yeah, go ahead. This is totally legal. Then in 2022, there was an Attorney General election. Drummond became the Attorney General of Oklahoma and immediately pulled that Attorney General opinion and said, I'm withdrawing this opinion. Hey, Charter School Board, you can't do this anymore. You need to rescind the contract that you have with St. Isidore. Well, the board ignored him and went ahead on the opinion of an advice from the prior Attorney General, decided to go ahead and keep the contract, and they were going to start the school. And that's when the Attorney General brought an original action in the Oklahoma Supreme Court challenging the validity of that contract and whether it violated the Oklahoma Constitution, the Charter School Act, and the United States Constitution. And so then that's where we find ourselves in this case by way of, background and what was going on at the time.
I appreciate that. Let me ask this question, and Mike, I'll ask this to you if that's okay. I used to serve on the state charter school board here in Utah, and we get applications for a school that's going to focus on sustainability. We get an application of a school that's going to focus on sports as their charter, some on academics, some on music. And so if I understand this correctly, there's a school that applied to the Oklahoma Charter School Board and said, our focus is on the Catholic faith. If that were to have happened even here in Utah and the LDS Church were to come and say, we want to open a charter school based on our faith, based on my understanding of the law, I don't think that would have gained much traction. So what basis did this charter applicant use to say, you should grant this? Was it these trilogy of cases? Was it the shift that you were talking about in maybe this new era that we're in? That's either some very creative lawyering or a lot of moxie, maybe a combination of both. But what caused that to take place?
I think it is a convergence of what's happening, dynamics in our society, and with the law that have created conditions where, for some people, let's just be blunt. For some people for some are going to hear, wait, a school that's going to be paid for by the state could be a religious school, and that's going to sound, from a certain perspective, that's going to sound crazy. From the other perspective, for someone, for religious communities or religious believers who have felt for decades that they have been excluded from the public space, have been unwelcome in public schools, who have looked to the school choice movement, not only because of the economic reasons that Bill mentioned, but because of the values and the ethics and the reasons why they want their children in private school, or they want their children in homeschool, or they want their children in a charter school that's controlled by a private board of citizens that might be more aligned with their general values as opposed to the State Board of Education. It's a breath of fresh air. And so we're seeing a lot that's going on in the dynamics of American politics and our legal development that are creating conditions here for something that is a sea change potentially. And I think maybe a helpful framing for this is to look just briefly at what's clearly not, or what's clearly an establishment and of religion in schools, what's clearly not under our current Supreme Court case law over the last several years, and then look at why this is just right down the middle of that, and very, very hard to peg one way or the other. It's very clear that if the Utah legislature right now, as they're meeting, they decided, hey, we're gonna commission a new public school that's gonna be or we're gonna have a Catholic school and a Latter-day Saint school, and we're gonna pick the top religions in the state by demographics, and we're gonna open up schools for the top 5 religious demographics, and we're gonna. That would be an establishment of religion. Everybody across the spectrum would agree that's an establishment of religion. You're creating a religious school. There's been public state discussion of it. It's not it's just public access. It's a state school. Now, on the other hand, and for a while, that's what, since the mid-19th century, with common public schools, that's been the state-directed way in which schooling has happened for a number of reasons, one of them being that trend that I described and of a hostility towards religion, as well as economic factors that Bill have mentioned. There's been this movement that has looked for choice in schools, and that now has this charter school system that is not one dominant at the top saying this is what the schools are going to be. It's people applying, saying, hey, can we do this? Can we take it this direction? Which is why when Joe asked the question and says, well, this school has this focus, and it's going to be a sport focus. This is going to be an economic focus. This is going to be a focus on the American founding. Well, is it that outside of the realm of our discussion to say, well, this school is going to have a religious focus? It looks like one of many different flavors that is coming and asking to be like any other, which is why a Supreme Court that has been, in recent years, has been disposed to free exercise concerns and has seen in cases of playground surfacing that you're not going to, under the old regime, it's like, oh, wait a second. Does a penny go to a religious school? I don't care if it's for asphalt. I don't care what it's for. There's no way we're allowing any penny to ever find its way to a religious school. That's out. Supreme Court now says, wait a second. If there are other schools that can receive money for asphalt, why can't a religious school receive money for an asphalt playground? And so that's one side. Now we're in the middle of it where it's, okay, the charter school creates a school. And so it is not it's not for the playground. It's right in the middle of this. It's right here because you're not top down saying this is a religious school, but you are a board that's saying, well, we're going to create a school, and so you're right in the middle of this. And from either viewpoint, you can have a basis to say, from your interpretation, why that is either a good idea or a bad idea.
Mike has actually argued cases before the Supreme Court, so I've got to be very careful on how I interject my questions. But anyway.
Haven't argued before the Supreme Court, have just filed briefs at the Supreme Court.
But still, very impressive. Erin, let me ask you this, because it's one thing to say we're going to give religious school money so they can put recycled tires on the ground. Isn't it a much different argument to say we're now going to give a religious entity money so they have the funds to teach their faith-based perspective? Because that's where we're at now, right? We went from, hey, this school can receive money so they can put recycled tires on their playground, to saying that same entity can now receive funds, and those funds can be used to teach the Catholic faith. They can be used to teach the LDS faith or the Muslim faith or the Jewish faith. And my next question is going to be to you, Bill. And it's like, well, what happens when the Church of Satan or the church, whatever you want to pick, they're going to show up and say, we want funds? But Erin, let's start with you. Like, is the leap too big to go from recycled tires to now pay for us to teach kids our faith?
No, I don't think the leap is that big at all. I think it goes back to those general principles of, it's a generally available public benefit. So they're allowing all of these other private entities to apply to be a charter school. There are Native American charter schools. There are French immersion charter schools. I think, we start seeing that the Charter School Act was passed in Oklahoma to allow for innovative teaching methods, new and different ways to teach children, to help cater to what parents wanted and what parents knew their kids needed. And so this is just another one of those options. And so, when you're thinking about the progression from Trinity Lutheran to Espinoza to Carson, I think that this case might actually be easier than Carson, because in Carson, there was no public school to go to. The parents had to choose. They only had the private school to go to in that area because Maine was so rural. And here, there are public schools scattered across Oklahoma. Like, they're not taking the charter school board existence and St. Isidore being a school is not taking away the option for parents to put their children in free public education run by the state. But these charter schools are independently operated by, in this case, St. Isidore, thus the Archdiocese of Oklahoma City and the Diocese of Tulsa.
Erin, let me just ask you a follow-up. Is the argument then, because the parent is the one deciding where those funds are going to be spent? Last year, Utah, the legislature passed the Utah Fits All Scholarship. And one of the concerns was, well, a scholarship recipient could take that money and use it to pay for a private religious school. And the counter narrative seemed to be, it's not the state telling the student to go to that religious school, therefore there is no violation of this perceived separation of church and state. Is that similar to the argument being made in St. Isidore?
I think that is, that's a pretty key factor, right? No one's being forced to attend a religious charter school. That was never the mission of St. Isidore. That's not what they want. And so that is one of their arguments, is that this is wholly voluntary. And not to steal, your thunder bill at all or anything, but the next question, it kind of leads into that next question. Okay, what if the Church of Satan wants to start a charter school, a religious charter school in Oklahoma? What if, the Islamic faith wants to start a school that teaches Sharia law? I mean, there are all sorts of questions about the legality of what, if there are mandates in a religion that would be contrary to what the law allows in the United States of America. There are questions about that. And it's really just this slippery slope argument that the Attorney General is trying to make, I think, in order to scare people from, thinking actually about their rights and their religious liberty rights. But what it comes down to is the money in Oklahoma. We are now an open enrollment state, pretty recently, within probably the last 5 years. The money follows the kid. So if you're going to enroll your kid in a specific school, then the money follows them. If there's not enough kids enrolled in one of these charter schools, the charter school won't exist. And so I think that is an important detail and fact that the court will need to consider is the voluntariness and the way that the money is being dispersed to these charter schools.
Let me follow up on that line of thinking. So if there is a school, and I understand the school can't teach things that are actively promoting things that are contrary to our laws, right? Or engage in activity in the school, religious or not. But what if there's a school that is based on the principles of polygamy? And they're not advocating for it, they're not encouraging people, but founded by polygamists, they promote that arrangement. If the Supreme Court says yes, religious institutions can open their own charter school, the state has to fund them just like they would anyone else, is there a limiting factor? Could that school that is actively promoting polygamy receive taxpayer-funded funds?
I think Erin's answer is probably the right one on this. It is not probably is the right answer on this one. If they're teaching something that's illegal and they're encouraging students to engage in illegal behavior, certainly that would be a limit on what they could do. But the general question of if we allow a Catholic church to start a charter school, do we have to allow Muslims? Yeah, of course we do. That's the First Amendment. And it's good to think about this, I think, in the way that probably I think many of the Catholic parents who are interested in this charter school are thinking of, and that is, if I wanted my child to go to French immersion school, I could do that. I could make that choice. And if I wanted to send them to a school where, the focus was on entrepreneurship, I could do that. But the choice I want to make is for them to go to a Catholic school, and I can't make that choice. And so I think that's an important framing. And the dissent in the Oklahoma Supreme Court case really drilled in on that idea. And the way she described it, which was pretty convincing to me, was that the state is essentially contracting with these charter schools to provide help. And that happens all the time. If you have like Catholic Immigration Services and there's some things the state can't do itself, but knows that they can do it, then they work with them to do that. And to exclude a religious school solely on the basis of religion, that's problematic. So in a way, this strikes me in many ways as being a relatively easy case, except for what Mike described, which is this Establishment Clause sort of ghoul that's sort of like, well, how do we square this with the way that the court has looked at the Establishment Clause all these years? And that's what makes us, I think, worried. Okay, well, if there's an Establishment Clause, then we don't have to ask these hard questions about what about that church with kind of beliefs that I feel are really out there. Then we can say, well, we just won't support any of them. And so we don't have to answer that question. But I think the Supreme Court has done us a great disservice in the way it's handled the Establishment Clause, and that may be one of the reasons the Supreme Court needs to take this case to settle some of those questions.
Mike, I want to ask you one final question, and then we'll turn some time over to the audience. Do we have time for that, Matt? Okay. So if you have questions, think about those, and you'll just come up, use the mic, or we'll run it out to you. But let's talk about this legal concept of state actor. If you could explain that to myself and the audience, because that seems to be a very, I don't know, is it a persuasive argument to say by giving this religious entity state funds, they really become an extension of the state? Is that a legitimate argument? Is that a persuasive argument?
Well, I think in that general sense of just any giving of money, any giving of money, that no, that's not sufficient. I think that's some of the concerns that you're seeing from people concerned with the Oklahoma Supreme Court's decision, is that it could interfere with a whole host of issues that Bill just brought up, for instance, with orphanages or other charitable services that the state contracts with and spends money to, where I think that the argument over whether or not the school is a state actor, what that comes down to is first of all, the distinction that would be drawn is that this is complete funding. This isn't just paving the playground. It isn't just tuition assistance of certain students that go to the school. It isn't just some donations or grants that are made to an orphanage. It is the entire funding, first of all, so it's complete funding. So that's something that makes this issue difficult. The second thing that makes it difficult from the state actor perspective of trying to determine this is that, unlike the other cases that we've described, where it's this general applicability and not discriminating against, in those cases, there's already an entity created that is asking for that's applying for the generally available funds, whether it's the playground funds, whether or not it's a student that's deciding to go in. In this case, you're actually the state is creating the school. The state creates the charter school. A private entity applies for it, but it's not and this may vary from state to state. The way that it comes in Oklahoma is that a private entity is essentially a sponsor, but it is not actually a school that is already formed. It comes as an entity, as an applicant that, in some respects forms the nucleus of it, and the state then creates the school. That's going to be the argument from Oklahoma's point of view of why this is going to be a state actor. Potentially, one of the arguments they could make is that you are, by granting the charter, that's when the school is created. And so that is the state action. And the reason why the state action is so important, this case could be decided a number of ways. If it is a state actor, then you are subject to the Bill of Rights. So the way these cases have actually developed have not been around religious schools. These cases, the law that the Supreme Court's going to be looking on this issue of state actor have actually developed over things like search and seizure, whether or not a school student at a charter school has the Fourth Amendment protection against search and seizure. And some states, I believe this is accurate with California, in the way in which one of these cases came out, they decided to assert more control over their charter school system, to remove kind of private boards and to assert control over it because of a desire to have the Bill of Rights applied and incorporated against these schools so that students would have, say, a Fourth Amendment right against search and seizure. You could see, depending on how this is decided by the Supreme Court, you could see with our federalist system, you could see some states choosing their charter schools to be state actors and some trying to run away from being state actors so that they are not, so that they are free if they desire in their politics to choose to have charter schools that are religious schools. So you could see red and blue states or other divisions among states of some choosing, hey, we're afraid of having religious schools. We're going to make sure that our charter schools are state actors. They are run by the state. We've got more control over it to make sure that it's clear so that there's not an issue that any of these charter schools that apply are going to be religious. On the other hand, you could see states take the opposite view and say, we're going to make sure they are not state actors, that it is entirely private, and really try to divest the state from it so that there's the potential for religious schools to be charter schools. It's a new era, and this case could certainly change the landscape in ways that would be felt for decades.
Thank you. I see we have someone with a microphone. Are there any questions from the audience?
This has been fantastic. Thank you all for joining us and for giving us such an insightful discussion of the issues involved in the context. I have a question about this because we've been talking about the provision of funds to the school, but something that often follows state funding is state control. So there's not a state private school board that oversees the private schools in the state. There's a state charter school board. So I'm curious, and maybe this is sort of a fact specific. That's actually helpful to me, Mike, that you pointing out that this could be a variation across states depending on just how at arm's length they hold their charter schools. But I'm curious, maybe specifically in the Oklahoma case, and then maybe more broadly, would the state then have a more extensive control over the curriculum, including presumably the religious elements of the curriculum, than they would over the school if it was a private school rather than a state charter?
Anyone want to pick that up? Bill?
You sure? It is very fact specific. In fact, the funding question is not as simple as it initially seems, I think, to most people, because the St. Israel will actually be picking up a lot of costs, like for teacher pensions and things like that. And so the way that Erin described it, where that money that they're giving, if a student decides, I want to enroll in the charter school, the Catholic charter school, then they get this. The school will get the money that student would get just kind of for fulfilling a seat in the public schools, and then any additional things that are needed to, say, teach religion or whatever else would come from private parties. And so it is going to be very specific from state to state. In this particular case, the state is relatively hands-off in terms of, they don't say that they will, impose. Some states actually impose on even private schools what they teach related, like health education, for instance. But so I think you would see some variation among states on that question, we kind of famously think of Chief Justice Roberts as being careful about, trying not to make massive changes. And the fact-specific nature of this case might really turn out to be dispositive of the decision. Well, in this case, yeah, maybe, given all of those things, and there's not the concerns with state control. But the state control concerns really can be important in a different way, too. And I know this was brought up by the dissent in the Oklahoma Supreme Court case, that if we say that because something is designated as being an official contractor with the state, does that mean that everybody who's regulated by the state? So the example that immediately springs to my mind is lots of people are given like a license by the state for to practice psychiatry and these other things. Do they become state actors by that? Well, we don't think so. Typically, we don't think so. But you're raising exactly the right question. But would that change? And if we say it's okay for a state to impose conditions on on a charter school that's otherwise private, do we then say it's okay for the state to impose impose other substantive regulations on the practice of psychiatry or marriage and family therapy or different things? So I think that's exactly a critical question.
Maybe I'll answer the question from a policy perspective of certainly a concern that religious schools might have with how things could change quickly. Let's say that charter schools can be religious schools, and all of a sudden your private religious schools are under pressure competition-wise and move into the charter school space because there's going to be pressure to be charging tuition when another school that is ostensibly a religious school, similar to your religious school, is not charging tuition. So you have potentially over a couple of decades, you have essentially an erasure of religious private schools that all become religious charter schools. Well, then what happens when politics change? And all of a sudden, whether it's a change at the Supreme Court, a change in national politics, change in state politics, and you have more assertion of control, the kinds of conflicts that can, of course, immediately come up for a religious school over issues of how sexual morality or sexual politics are taught in the schools, issues over diversity, equity, and inclusion. All of these are issues that can be confronted, and then you have a charter school that is receiving funds from the state. It has a religious mission, but it has some level of regulation or tie to the state, and it creates, obviously, challenges. We brought up earlier the issue of what was Erin had described as a slippery slope of what might be considered less estimable religions, or at least concerns for particular religions and what they might teach, or certain doctrines they might teach. There's also another there's another difficulty here in the exclusion of those. So if, and there's questions about it from a free exercise perspective, it's going to be, well, you can't exclude those schools. Then there are problems with concerns with schools are excluded, but it's not expressly on that basis. Nobody knows why the Islamic school, charter school, was turned down. Oh, we didn't think that you were qualified enough, and et cetera, et cetera. But wait a second. Then we go in and we dig in the charter school board, and he had one member of the charter board had anti-Islamic statements that he'd made on his Facebook post. And so then there's these questions, and the reality is that religion is, in some respects, it is different. And the government getting into deciding which of the religious schools it's going to favor with charter school status and which it isn't is more complex than the government deciding which sport or which economic interest or which business interest or which flavor of its deciding in American history, because it is religion, and we have a First Amendment that says that there is neither an establishment nor a free exercise of religion, and we're generally uncomfortable with government making judgments about religion one way or the other at all. That's, in some respects, why we saw such an extreme, although in my opinion, unbalanced pressure for many years that have excluded kind of religious discussion. There has to be a way to have plurality, have a vibrant religious community, what George Washington and John Adams envisioned as the necessary supports for our republic of religion and morality, and having this in a way that allows for a vibrancy without the government interfering and excluding on one hand or the other, and without such resistance that we can't have any religion at all. It's not easy, and that's what we're going to see with the Supreme Court case. This is not going to be an easy case to address.
They say that only the hard cases make it to the Supreme Court, right? The easy ones, they get settled by the lower courts. Our time is up, but I just want to, we ran this through AI, and I said, knowing everything AI knows about every justice on the Supreme Court, and AI knowing everything you know about this case, its history, what is your prediction on when does the decision come out? Before June 30th? Is that this summer? What do you think, AI, the decision will be? And it had an analysis behind this number, but to the extent AI is right about anything, AI came out and said they foresee a 6-3 decision in favor of St. Isidore. I sent all that data to each of the panelists, and because time is short, we'll start with Erin, but if you could just give us a very brief, do you see things the same way? Why or why not? And again, maybe try to keep it 2 minutes. Thank you.
Sure. So you want me to just like 2 words or 2 minutes?
2 minutes. Let's do 2 minutes.
Sure. So I read through the answer from AI, and I use ChatGPT in my everyday life, so I tend to agree usually with it. But yeah, no, reading through it, I think that generally speaking, it's correct. I think, Chief Justice John Roberts has wrote the 3 opinions in the 3 free exercise cases that we've seen about, generally available public benefits. And so I could see him, I agree that I could see him authoring the opinion. I don't know about the number, because we're not so sure about Justice Barrett and whether or not she will play a role. She recused herself from the decision of whether or not to grant cert, but then we haven't really seen anything about that or why she did that. Maybe presumably because one of the parties is represented by the Notre Dame Religious Liberty Clinic, and maybe there's some personal ties there that we're unaware of. But anyway, that being said, I agree. I don't think St. Isidore is a state actor, and so I don't foresee any issues with that. And thus, even if we're talking this, even if the court says, okay, yeah, maybe state actor, maybe not, they start to fall in the middle. They're not really sure. I think the court recently has said, and most recently in Kennedy versus Bremerton, starting to clear up their Establishment Clause jurisprudence that's been so confusing and messy and not super clear about what's allowed and what's not allowed. Just saying, we can't use the Establishment Clause as a weapon against the Free Exercise Clause. And a lot of what the Oklahoma Supreme Court, it looked like they were doing throughout their opinion, was building up the Establishment Clause to knock down the Free Exercise Clause. And in fact, they almost end the opinion by saying, even if St. Isidore had free exercise rights, the Establishment Clause wins and would defeat the Free Exercise Clause, which the court's been pretty clear recently that you can't use the Establishment Clause to beat the Free Exercise Clause because they have to be read in harmony. They're a part of the same phrase. So I think I tend to agree generally. Some of the details I'm not so sure, but that's my answer.
Mike, you referenced this earlier. It's not like there is a yes, you win, no, you lose. There's a multitude of possibilities, but your thoughts on the AI analysis?
Well, I think as Erin mentioned, we don't, it seems likely that Justice Barrett's not going to participate in the decision, so we're down to 8 justices. A Supreme Court decision depends on those 8 justices and how they decide. I think AI has a pretty safe bet that there are at least 3 justices that are going to affirm the decision of the Oklahoma Supreme Court, are not going to be in favor of the creation of a religious charter school. I think that's very safe right there. You've got 3 votes that are absolutely that way. I think it's probably a pretty safe bet you have 4 votes on the other side that are for reversal and that are going to see this as a similar progression from the 3 cases, the free exercise cases that we've been talking about, and see it as simply another step, maybe a bigger step I mean, it is obviously a bigger step. I think from their perspective, whether or not it's little or big, hard to say, but I think it's probably a safe bet. You're going to have 4 justices that are absolutely in line with seeing this as another incremental step in this kind of diversity and treating religion like other elements of our society and our educational system. And I don't think any AI machine is equipped to say the mind of Chief Justice John Roberts. I think trying to predict how the Chief Justice will see this is very difficult. The one prediction I would make with respect to the Chief Justice is that if he does side with the other conservative justices, he will desire to write the opinion himself. He's written the previous opinions because in my estimation, and estimation of many others, he wants to keep things this would be sort of a conservative judicial philosophy, not conservative political philosophy, but conservative judicial philosophy that you take small steps with the Supreme Court. And because of this case's potential to really to change the dynamics of our school systems and church-state relationships, there's no question that if Chief Justice sides with St. Isidore, that he's going to want it to be as narrow a change as possible. That much, I think, we could safely say, but whether or not which way he comes down, I'm not smart enough to know that.
Bill, why don't you give us the last word?
Well, I kind of feel tempted for the sake of diversity to say I think they're wrong, but I hope it's right. I hope that the state actor doctrine is repudiated in this particular case. I think it would be a bad result for the Constitution. What I do hope, though, is that the Supreme Court does talks a little more about the Establishment Clause. This is an area where it's kind of been a history-free zone, but our Constitution needs history. It needs, sort of to speak for the originalism community, it needs to look at what the text of the First Amendment says, which is that Congress shall make no law respecting an establishment of religion. So, that doesn't require this kind of bizarre thing where we have to decide is the state too close, not close enough, all of that. That needs to be repudiated. And so, well, I think it does. I suspect the court won't, for the same reason you described. I don't support the court won't do that in this case, although we might get a great concurrence from Justice Thomas saying that. He said that before, and I think he's right. But so I don't know. Every prediction I've ever made about Supreme Court cases has been terribly wrong, and the one I spent the most time on and filed many briefs in, we got a decision that was entirely unrelated to the issue. So I won't make a prediction. That's how I'll be different from everyone else.
Just thank the panel with a round of applause. And again, thank you to UVU and the Center for Constitutional Studies.
Thank you, Joe. I'm really grateful to all 4 of you for helping us understand what's shaping up to be a very complex case, and one that delightfully, for someone like the Center for Constitutional Studies, at least confounds some of our priors, right? Leaves religious believers and devout people and folks who are attached to religious education thinking, boy, is this a Trojan horse? I'm going to take the state's money and take the state policy with it, so it's really helpful to find an angle on this issue that involves us in thinking through some of the trade-offs that are involved and thinking carefully about the structure of religious liberty in our community. So thank you all for doing that for us. And thank you for attending the conference today. This is our concluding session, but I'd urge you to check out some of the other things that the Center for Constitutional Studies offers. I've pointed out earlier in the day, we have a podcast. The QR code pops up on these screens periodically, and you can find a link in our YouTube channel. This Constitution, it's a podcast for we the people. About their Constitution, and we're doing our current season that's going to launch just next week. Season 2 is going to be on checks and balances, on the top of everybody's mind right now. And please do keep an eye on our events page. We offer things not just for the community and not just for students, but even to our littlest citizens. Our Learners with Littles program invites parents with small children in. To do things like this. Our Visible Hand program is serving the business community with civic education, nonpartisan civic education. And so we want to be a breath of fresh air, helping promote constitutional literacy, civic discourse in our community. So thank you for being a part of that, and I hope to see you again.